Good morning, everybody. Thank you so much for joining us today. We're covering Stage 2 ACT Strata reforms. I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, a body corporate management company in Queensland. I'm your host for this webinar today, and we're delighted to welcome Shelley Mulherin from Thomson, Geer and Nina Cannell from Signature Strata. In 2019, the ACT government initiated a two-stage reform. The reforms were initially motivated by building quality reforms and an ACT government planning review. Both the first and second stages of these unit title reforms have commenced, and you may or may not be aware that Stage 2 officially commenced on the 1st of July 2023. Nina and Shelley will be stepping us through the changes and what they mean for you and your scheme. Now, before we begin, I'd like to mention that the information in the session, including the discussions that arise from submitted questions and also conversations that occur in chat, is not legal advice and should not be relied upon as legal advice, and you should always seek independent advice before acting on the information contained in the session. We welcome Shelley Mulherin from Thomson Geer. A proficient dispute resolution and litigation lawyer, Shelley acts for local and national corporate clients across a range of sectors, including strata development and building and construction. Shelley is the current president of the SCA ACT and a member of Master Builders Association ACT Professional Sector Council. She is a regular contributor to ACT government consultation panels in relation to the regulation of professional services, strata and unit titles reforms, and law reform issues more broadly in the ACT. And we're also delighted to welcome back Nina Cannell from Signature Strata. Very few Canberra strata managers can boast 20 plus years of professional and practical experience with the level of knowledge and insight that Nina provides. Nina is devoted to educating strata communities and mentoring generations of strata managers. She's well respected, committed to best practice, and passionate about growing our industry reputation, both within the ACT and nationally, and is the current SCA ACT Vice President. And Nina is also a regular contributor to LookUpStrata and helps to provide answers to strata questions for our ACT audience. So Shelley and Nina, we welcome you both for joining us today.
Thank you, Nikki. Lovely to be here. Hi, everybody. All right, welcome everybody. Stage 2 of the ACT government's strata reforms. Just first up, an acknowledgement. I'd like to begin by acknowledging the traditional owners of the land on which we meet today. I'd also like to pay my respects to elders past and present. All right, the Thomson Geer slide. Look, it doesn't actually include a disclaimer as to legal advice, but I'm very grateful to Nikki for popping that in there. I am a partner at Thomson Geer. I know a lot about the law. The reason we give those disclaimers, obviously, is to ensure that you understand that the particular circumstances of your matter are not matters on which we can give advice in a forum like this. That being said, there's a fair bit of legal content to go through today, and I'm open to obviously discussing these reforms in a really frank and hopefully clear manner with everyone. So Thomson Geer is a major Australian corporate law firm. We're across the country. We're able to say we're one of the largest 10 firms in Australia, and we're a full service firm. So essentially, unless your matter relates to crime or to family law, it's likely of the kind of work that Thomson Geer does. So I just wanted to pop in a slide at the commencement just around our strata profession, and just to acknowledge, I suppose, that this industry is continuing to progress towards professional recognition across Australia. In Australia, we've got these a professional standards scheme known as the PSS, and that's a legal instrument that can cap damages that a participating member of an occupational association can be liable for if there's a court finding against them. The reason that's relevant and important, not just for strata managers, but also for owners and other participants in this space, is that admission to the professional standards scheme is really only open to professional associations, occupations who will regulate their members to improve professional standards and as a consequence be protecting consumers. So I think that's a really exciting development. for the strata industry. At the moment, there's only a scheme in New South Wales, but I expect over the coming years that the SCA nationally will move towards PSS accreditation. So for those of you already in the profession, you'll be hearing about this over the coming years. For those of you who might be executive committee members or owners, please know that this is an industry taking itself seriously and dedicating significant resources to the increasing professionalisation of the services that are provided. Okay, we're here to talk about strata reform. Many of you will be familiar, and particularly if you were able to come to the first session with Nikki and Nina in relation to these reforms, that this has been a significant reform project for ACT Gov. What they were doing was looking at unit title laws and policies and considering how they could be better improved to generally support people living, working in strata and mixed use developments in the ACT. I think that's exciting because obviously we are defined by some pretty proximate borders, and our ability to keep growing requires us to keep building. It requires a fair bit of infill, as they say. The ACT planning strategy has set a target that 70% of these new homes will be built in existing urban areas. So we've really got a government focused on and committed to sort of building up this city. We'll see more people living and working in apartments, townhouses, and mixed-use developments. And of course, for those of you who might practice across jurisdictions or might own units in more than one jurisdiction, you may be aware that the ACT has not been at the forefront of the development of the law in this area. That is to some extent consistent with how our laws are often made in the territory. We don't typically tend to be first unless we're talking about issues that might resound with our local political agenda. And at the moment, those tend to be, I mean, there's a bit of media at the moment around some of the drug reform legislation that our government's doing. It's a very interesting place to live, but for strata legislation, it hasn't meant a proactive approach in the territory. In fact, it's sort of meant the other. So for those in the industry, I think we felt like this was probably pretty well overdue. And that consultation process, so before the reform had even begun, as Nikki said, around 2019, there was industry consultation happening back as far as 2016. I've just popped up on the slide there the groups that have been engaged with the government in consultation. So I mean, having a government committed to actually looking at unit title laws was obviously exciting for us. It probably sounds a little bit nerdy, but it's a huge opportunity where there's political will to make actual changes to the legislation in the territory and really make some law that would better deal with our mixed use development situation, which, as everyone would appreciate, before stage one of the reforms was very rigid. So there were extensive consultations undertaken, and then the internal government review, which has sort of happened since 2019. 2 stages to the reforms. The first stage commencing in November 2020, second stage, as Nikki mentioned, commencing 1st of July 2023, sorry. Just a very quick refresher here on stage 1. I do this because it's important, I think. You know, it's actually not been around for that long, and the reforms in stage 1 were quite significant, but I'll just keep it light. We went for better decision-making processes for owners' corps to deal with financial matters and rules. So this for us meant ability to split budgets, raise levies other than on the basis of unit entitlements. You know, that was a really seismic shift for some operators, owners, being able to actually respond to the particular needs of an owners corporation and to be so much more flexible with what might be an equitable distribution of cost in a particular scheme. We also saw some really enhanced disclosure requirements for sellers of off the plan. That has massively increased the amount of information available to buyers. And I don't necessarily know how property lawyers feel about it or how purchasers have been responding to it, but it has required a lot more disclosure. And for the interested and engaged purchaser, there is a lot more information available about the property that they're going to purchase. Building management statements also arrived. I think that's probably one of the most significant reforms. They had already existed in New South Wales. They had some good support, I think, in the consultative stages as being recognised to be a document that could really help us all move forward to manage more sophisticated arrangements within strata. And of course, we were told that pet-friendly unit plans were to be encouraged, and we got a whole new suite of pet rules and a presumption broadly in favour of pets. So that'll happen back in November 2020. The building management statements, as I mentioned, I think were absolutely key. They are now mandatory for new builds. Don't expect we've got any developers on the webinar, but if we do, they will be aware. Anything that's going up now in the territory where there's more than one lease must have this BMS. Obviously, if it's unit titled, it's likely to apply. What about those owners who may have wanted to opt in, however? So a BMS is not mandatory for existing buildings, but there's now a mechanism and a bit more clarity around when that opt-in process can be enlivened, which is via a special resolution. Really what it is, I'll go to the next slide actually. It's got in it a whole heap of really relevant pieces of information about the building, information about resolving disputes, information about building management committees, information about establishing and appointing office holders, processes. It's quite an extensive and detailed document. And it then gets registered with the Registrar General of the LTO. And that means that when someone's coming along looking to see what's involved in the building, they can search up these documents by accessing on the certificate of title. You'll see the registered instrument and it can then be obtained and reviewed. So I suppose it sits hand in hand with this enhanced developer disclosure. I've called it developer disclosure, but it's essentially disclosure on the sale of any units. The ACT government at the time, and I think continues to have a really consumer-focused agenda. They were faithfully trying to make decisions that would protect purchasers. And, you know, those purchasers are our future lot owners, our future clients, our future neighbours. They were trying to maximise transparency for consumers in deciding to purchase. And they were looking at accountability in the conveyancing chain, you know, from developers to sellers to strata managers. So it was an extensive, well, it was a wide scope, and I think some pretty good reforms. Stage 2, and I've said to a few people actually before we had this webinar that I was, you know, not sure there'd be enough content for an hour to discuss and all this sort of thing, but you know, really on getting into the detail of the Stage 2 reforms, there is quite a bit here. I'm not professing today to deal with everything. If anyone is interested enough, there is a now repealed Amendment Act that will show you every single little change. I've focused in on what I think will be relevant to the audience and interesting. So the path to these reforms, essentially consultation, as we've spoken about. I should acknowledge the fantastic contribution of the OCN in that process. I don't know, some of you on this call may be members. It's really useful to have a lobbying organisation that can be a little bit hand in hand with the Strata Community Association when we've got the ear of government and we're just trying to urge on them the importance of really productive, useful law reform. So a bill was presented by Minister Gentleman in 2023, and ultimately the Unit Titles Legislation Amendment Act 2023 came into force. as I say, the reforms commenced 1st of July 2023. So everything we're discussing from here on in is live, it's operative. You want to know about it, it is the law. So what did the SCA do? In that consultation process, we were really talking about what the law reform should be. We were looking at drafts, we were giving feedback on implementation, and to the extent we were permitted to do so by the terms of the engagement itself, where we could share some limited materials with our key stakeholders like board members. It was a really long process, and all of those stakeholders that we've talked about put in significant time really assisting the government to understand these issues on a practical and day-to-day level. None of this is perfect. I actually think there's a lot more to do and that could be done. So in the ACT, in terms of what has in fact been done, we've amended some legislation. That legislation is up on the screen. Any lawyers in the strata space will be very familiar with these 4 pieces of legislation, in particular the Unit Titles Management Act, which I think many of us use every day, but also the Unit Titles Act, Land Titles Unit Titles Act, and our Civil Law Sale of Residential Property Act. In terms of the key reforms themselves, one of the principal reforms was in relation to rules and registering up-to-date compilations of those rules. The act that was amended is the Land Titles Unit Titles Act 1970. And what we have now is a new law that requires all owners corporations to lodge, and I'll come back to that, the most up-to-date compilation of all of their alternative rules each time they change a rule or rules. So just to give you some context, back in stage 1, one of the reforms was to adopt default rules. And so when those reforms passed, effectively the default rules came to be. But of course, owners corporations can amend the default rules. However, the reforms that we implemented in stage 1 meant that if you just amended one of your default rules, you just registered that one amended rule. So we were beginning to get this situation where you'd have these ad hoc amended rules registered on title, and that was not considered to be achieving that consumer transparency agenda. So we've come back around to say, well, that's not really quite good enough. What people need is a full suite of the rules, the up-to-date rules. And so now that is what the new law requires. It is absolutely to give prospective owners, prospective purchasers access to a full and up-to-date set or compilation, which is the language of the Act, rules when they're purchasing. It's probably a little bit of an increased administrative burden for those tasked with performing that lodgement. But because the rules fundamentally govern the owner's relationship with the owner's corp and their own property, it was just considered to be too significant not to correct. So ultimately, it's strata managers primarily registering these up-to-date compilations. I'm saying registering. The rule now says to lodge them, and I'll just explain that distinction briefly. Lawyers in the room will be very familiar with it. When we go to a counter, court registry, Access Canberra, wherever it is, and we hand something over to them, that's the act of lodgement. What then goes on behind the scenes, either at Access Canberra or a court registry or wherever else, is a process of registration, which ultimately ends with that decision-making body registering, recording to title, receiving a document, etc. So this change was an insightful one and brought about by people with a good practical understanding of what goes on here to require actually strata managers or your self-managed DCs to have lodged those documents as opposed to needing to have seen to their complete registration within the prescribed period. The concern was that after lodgement, it's out of the hands of the lodging party how long it might take to register rules. And there are some real teeth in the law here in failing to register alternate rules, i.e. the rule's not valid. That's a problem. And it was thought, obviously, that there was a huge risk of invalid rules in circumstances that really were beyond the control of the relevant parties. So the reform requires the lodgement as distinct from the registration, but of course the lodgement still has to happen within the same period. So it's not a case of this is going to be easier now. The time period still applies, but you're less likely to fall foul and cause an invalidity issue, provided you've had the rules lodged within that period of 3 months. Okay, I'll just go on and talk a little bit now about the insurance changes. First, in relation to exemptions. So there's been an amendment to the Unit Titles Management Act, and it relates to our friends in Class B. Anyone outside of ACT may or may not be familiar with this. We've got two classes, Class A, Class B. Essentially, Class Bs are quite commonly in the type of build of townhouses, and Class As are more like an apartment block. It's not how the legislation defines the distinction, but for practical purposes, it's an easy way to conceptualise. So because Class B townhouses often have less shared infrastructure, typically lower value common property, they can have or are entitled to some slightly different consideration in the insurance space. So the new law permits Class B unit owners to pass a unanimous resolution to exempt themselves from taking out building insurance. If they do that, they have to register that resolution within 3 months, which again ensures transparency for someone buying in. They'll see that the owner's corporation does not hold building insurance and that building insurance is a matter for the owners personally. Why did we make this change? Well, previously, those resolutions could be made, but they had to be made annually. And in practice, they aren't. I think in practice for smaller Class B plans, a lot of this is observed in the breach, and it's problematic because, of course, insurance is a requirement of the legislation for very good reason. And the feedback, I think, to government was, look, Class B unit owners aren't even aware necessarily whether or not the appropriate insurance is held, whether or not the appropriate resolution has been passed. So I think the amendment's a sensible one. It does have to be unanimous and it does have to be registered. Class B owners were sort of considered to be able to make decisions to cover their own unit, particularly in circumstances where they might not have significant common property assets. So that question of asset value also gave rise to a separate exemption, which can affect anyone. But essentially, if the replacement value of all the common property is less than 10K, then by unanimous resolution, a plan can exempt itself from building insurance. That amount of 10K is in the regulations, can be changed at any time. No real reason to think it would be. It's pretty low. I think that reflects the risk. So, you know, the driveway, etc., is really down below that amount. Why would we have legislation in the ACT that required the owner's corporation specifically to hold the requisite insurance? And can we not, I guess, step back and give these guys a little bit more room and space to breathe and make their own decisions? Okay. The question of the excess. I find this comes up so often. I'm asked about this all the time. In stage one, there was an introduction of a section 100A of the UTMA. The responsible entity for a units plan is required to lodge an insurance claim and pay any excess in relation to the claim. I'm talking there about claims on building insurance. But what was apparent as soon as we made this amendment was that there was real confusion about the effect of this section, particularly in circumstances where an owner might have been the cause of the insurance claim. So we're often sort of asked, like, where's the equity in someone who negligently causes us to have to, the EC on behalf of the OC, to make a claim on our building insurance and pay the excess for it and spread the cost of that excess back to all owners, you know, question mark, question mark, question mark. So that question, I suppose, came to the government for some consideration. And what we did in stage 2 was really just clarify that, look, we've got these rights in section 31. They allow an owners corporation to recover expenses due to willful or negligent acts. Why don't we use that power and connect that to the question of the insurance excess? So I'll just pop up on the screen now what section 100A actually looks like. I've bolded the note there so you can see. So an expense incurred because the willful or negligent act or omission or a breach of an owner's corporation rules by a member of the owner's corporation or an occupier of the member's unit, relevantly, may be recoverable from the member as a debt. So that's now a note that exists in the insurance section. And section 31, I mean, it's really repeated now in the insurance excess. So what the review committee tried to do was connect these two concepts with a view to reducing the pushback of seeking to recover the excess per section 31 from the owner or occupier who had behaved in a manner that was not consistent with the rules. Okay, our next key reform relates to developers' unit title applications. What is the new law? Well, it's really changing the required documents to lodge a unit title application. For those who don't know, unit title application is the administrative paperwork by which the ACT government decides whether or not to approve the unit title application and create then the owners corporation. Previously, I mean, the concerns that we were hearing was really around the difficulty in getting all the required material together at the relevant time to make the application. So it's really designed to facilitate an application being able to be made to the government with required material, which is often from other government departments, to filter in before the application's granted, but so as to lower the roadblocks to actually making the application. So it's more of an economic reform. You know, what good is it for Canberrans if we're slowed down even in the process of applying for unit title applications or DAs. Okay, subleasing common property. I hope I'm going okay for time, Nikki. I'm getting through it. Thank you. I think this is my favourite reform. I think this is incredibly interesting stuff. This is an amendment to the UTMA. I've called it a bold step forward for OCs. You'll be unsurprised to learn it's happening in many other jurisdictions, but it's a bold step forward for OCs in the ACT. You can now take steps. You got to take them cautiously and you got to take them with advice, but to essentially permit commercial activities on your common property by sublease arrangement. A lot of people, I think, would think, why not do this? And I think I'm in that camp. You know, provided the owners corporation obtains a special res, and provided the common property is not already subject to a special privilege, obviously, if you've already granted a privilege, you can't come in over the top of that with a sublease. And critically, provided that it doesn't, what we say, unreasonably interfere with the use or enjoyment of a unit, then the legislation now says you may go ahead, sir. The government, I popped a little quote on the slide, said in their way that I think is appropriate, but it's just got a level of, you know, back to you, strata and owners, to really work out the detail here. It'll be a decision for the owners corporation to determine what businesses or activities best suit their complex, common property and residence. So any sublessees that are coming on have to take out and maintain public liability insurance, and these arrangements can last for 5 years. So when I say a lot of people thought, why not? And I thought, why not? The rationale is, of course, that at law, all the owners own the common property. we just didn't see a reasonable justification for preventing owners from putting assets that they own to a use that could support, facilitate, or enhance their own living arrangements. It was a little bit of maybe some of the more prescriptive aspects of the legislation could make way now for arrangements that are consistent with other jurisdictions, but principally that could just make people's lives better in their apartments. Is there going to be uncertainty as to what constitutes unreasonable interference? Probably, yes. The results of the reform are that there are some examples as to what would be unreasonable interference. I think they're pretty straightforward. And at the end of the day, this is what our tribunal is for in the ACT. If reasonable minds can't agree, disputes go to the ACAT. So I can certainly see a live space for some more disputes as we start to see more common property leasing occurring and owners and occupiers having particular views about whether there's any interference with their occupation. There's this really interesting section in the UTMA which says the owner's corporation can't run a business, and that is unaffected by these reforms. Why do I say that's interesting? Well, there's a little bit of silence as a result of the subleasing about what income can be generated and what you can do with it. So I just would say approach with caution, take good advice. It remains the case that the owner's corporation can't run a business, in quotation marks. In a lot of instances, an owner's corporation would say it wasn't running a business by reason of installing locker banks, having a coffee cart, etc. But it's something that's got to be approached with some care and some thought. And I mean, if anyone in this group is in an executive committee that might be considering now or looking at an offer to lease part of the common property, I've said in big capital letters, go and see a qualified and pragmatic property lawyer. There's some nuances here, and it's not the role of the legislation to essentially answer every question, but I guess I'd just say it's still a sublease. It's got to be lawful. You want someone who understands leasing to come in and just make sure for you that nothing about this arrangement is going to infringe on any of the laws in the ACT or any of the rules of the Owners Corp. So I'm really looking forward to seeing some of this and seeing it happen and seeing more vibrant and buzzing opportunities in our buildings, but I think time will tell. The next reform's the audit requirements. Strata managers will be aware stage 1 prescribed an audit at 250 and referred to that 250 grand as being an annual budget. A little bit unclear what annual budget was supposed to mean. This wasn't really defined anywhere in the legislation. The stage 2 reforms have clarified that issue. It includes levy contributions, it includes OC's income, and it includes any other amounts that the OC holds. So if in doubt, count it. Take into account all funds held in calculating that amount, and I understand this is similar to the approach in New South Wales. Sustainability infrastructure, again, a bit of a hot issue for the territory. We've amended the unit titles management regulation in this case, and what the stage 2 reform has done is add examples for where permission to install sustainability infrastructure might be withheld. Financial considerations, equity of access to common property, easements, utility services, or facilities. Why? Well, to help address circumstances where the installation by one owner of sustainability infrastructure might impede another unit owner's equal access to similar sustainability infrastructure in the future, or might put a huge cost on unit owners. I wondered if people were going to say to me, is this because of our EV charging agenda in the ACT? And I think the answer is sort of, but not exclusively. Installation of EV charging points within common property, within unit holder property, the concern in that space is that it could impact significantly on electrical loading for existing conduits. It could prevent others from installing similar infrastructure, because that then the second, subsequent, fifth, 10th owner might cause the overload, or it could require the building to need major upgrades, which could be prohibitively expensive. Again, the legislation isn't supposed to put owners in a position where they must do something that, but for the legislation, they would reasonably otherwise not wish to do. So it's really trying to clarify when it was appropriate to withhold consent. The sustainability infrastructure section itself is in the UTMA at 23. It's a good section. It's detailed. It's pretty self-explanatory. It sets out that the OC may only approve in certain circumstances and after they've considered a whole range of essentially prescribed information. What we're talking about, though, that are decisions by the Owners Corp to install sustainability infrastructure on common, it's decisions to install it on common property, and being mindful that it could affect owners, could result in additional levies. We're just trying to assist to make OCs aware that their consideration of approval of sustainability infrastructure should really take into account all of these issues to the extent they reasonably can before they make those decisions. Updating Section 119 certificates, I think, is close to my final key reform. What we had earlier was a little bit of confusion about when an update certificate could be requested. We've now got a new Section 119 sub 2, which states that an eligible person can only get an update within 4 months after the day that their Section 119 was given. It's really to ensure we're not burdened by repeated requests, and also balancing the need for an update in the course of a conveyance for a unit. I just wanted to note to the strata managers who might be online, this Section 119 certificate is such a central piece of disclosure material for buyers. It's critically important that it's correct and current and as required by the regulations. And for any owners who might be in self-managed plans, this is a real area of risk and potential liability, I think. But in any event, you've still got 14 days to give it. You've got 14 days to give the update from the request. The request's got to come within the 4-month window from your first issue of the Section 119. So I hope that's all right on timing. I've just hit my Q&A slide.
Perfect, Shelley. That was wonderful. Thank you. Okay, so we did have, I had a few questions that I'd written down, and we had questions that were also submitted in chat. But you're right, when you mentioned about the sustainability infrastructure, I did write down EV charging, so that was something I was going to ask you. So you have addressed that while you were speaking. But we had a couple of other questions. I also had a question too that was when you mentioned about opting in if you're an existing building to the BMS at the beginning, what would be a circumstance where a building wouldn't opt in? Why would you choose not to opt into something like that?
Good point, Nikki. I think the arguments for opting in are sort of more suited to a need to have a more sophisticated layer of management within a building. You could still have multiple leases in a building, but consider those to be simple enough as perhaps not to warrant the cost of entering into the building management statement. And, there's also sort of a level of management associated with it. So you want to match, I suppose, the needs of the building. And I'm using the language complexity, but, how many services are there? How do they need to be split? And I think that the increased complexity will tend to justify the entry, whereas balancing that against the cost, there would be circumstances where you just may not consider that the building warranted it. I think there's a lot of benefit to doing it, but of course, on the other hand, there's cost.
Okay, fair enough. Thank you. We were also asked, where does the BMS timeline start? If a building is being built now, will it have a BMS, or are new builds that had their DA approved previously not captured?
Ooh, who asked that? That is technical. Thank you. Look, the answer is I don't know off the cuff, but I would expect DA approvals happening now. Well, because this all occurred, the requirement for the BMS for new builds occurred at the stage 1 reforms. So I would expect DAs approved post that date would require it. Certainly, unit title applications approved post that date will require it. There's huge benefit, I think, for owners, for ECs, for OCs in now being entitled to all the documents that the developer must provide pursuant to the building management statement that, unfortunately those in older buildings don't get the benefit of. Even if you are to opt in now, what the building management statement will require, you're not going back to find your old developer from 30 years ago and shake him down for the plans and the specifications. It won't work like that. But I think the benefit remains, but that benefit for existing buildings to opt into the BMS is really more forward-looking. It's about the management and structuring and existing in the building moving forward.
Okay, and we had a question specifically for you, Shelley. When does a change in the rules take effect? Is it at the OC meeting that establishes the change, EC granting a special privilege, or when the rule has been lodged, or at some other point?
Yeah, so there's a lot to this, and it's just because there's actually, as everyone will know, decisions made at meetings are different to decisions made at reduced quorum meetings. So the decision to amend the rule takes effect when that decision takes effect, but the obligation to register the amended rule runs from the time that decision takes effect. If the obligation to register the rule is breached, the rule's invalid. It never existed. So it's a sort of a two-parter. One, when's the decision to amend effective? That starts your timeline to get your registration. That's a formal process unless you stuff it up, in which case you've invalidated your decision. So yeah, hopefully that's clarity. I'm looking at Nina as well. Feel free, Nina, to
No, I would have said much the same as you. So when the decision itself becomes valid, so after your reduced quorum period, which in the ACT, relatively speaking, most of our meetings are run on the basis of a reduced quorum. So you'd have that period. And then, yeah, I wasn't quite sure about the lodgement process, but I think I would have thought, practically speaking, that it would come into effect with the effectiveness of that decision.
Yeah, and of course, for reduced quorum, that decision can be challenged in that period. If it is successfully challenged, it never became effective.
And what are you finding out there, Nina, at the moment? Since the 1st of July, if people are changing their bylaws or amending them, are they aware that they need to submit or register, or what was the word? Sorry, it wasn't register, was it, Shelley? It was lodge.
Lodge.
Are they aware that they need to lodge a full set of their rules?
Practically speaking, we haven't seen a lot since, or my office hasn't seen a lot since 1 July. With the first stage of the reforms, there was the obligation to register a consolidated set of rules. Because that was such a short duration ago, we're finding that there haven't been a whole lot of changes since then. So most of them have actually lodged those consolidated rules following the first set of reform, and we haven't actually seen any come up as yet. But as a standard process within our office, that's something we do anyway, which is probably good practice, so that you have got a single set for our reference, for the owner's set reference, and that's legislation aside. But you haven't seen a lot since 1 July.
Okay, all right. And Shelley, have you found that as well? Do you see many come through, or?
We typically see these issues when they go wrong. So we're more commonly asked about the validity of a rule. What's the consequence of, has there been a failure to now lodge, previously register? What's the effect of that? Where do we go from here? I think it's really a minefield space. And I say that because we're also working with not hand in hand with the tribunal, but the tribunal's our decision maker, and what they say creates law in the territory. And so we're also sort of seeing a bit of emergence in that space. And that's why I say with some degree of confidence that the risk of invalidity is a real one. I think that big change, Nikki, to answer that question, was the stage one, the default rules coming in, the need to amend. I think we had pretty good uptake in education around that stage one change. That also, at stage one, we had the changes, Nina, to the special privilege
We did. Yep.
issues as well. So those also needed to be registered. And if they weren't registered within a transitional period, they became invalid. So it was a bit of a cultural shift, I think, for players in the space from this notion that our meetings had a degree of autonomy and authority into this more consumer focused, transparent landscape where, yep, our meetings have authority and they're important, but there is a process of registration with respect now to almost all critical aspects of our decision making that requires that formal lodgement or registration, with a view to protecting our incoming purchasers, our new people. And of course, it protects existing owners as well. You know, if you're not sure, if you can't get an answer, if you want to challenge something, you can also get your title, search it up, check what's registered, and go off and see the ACAT if it's something you are taking issue with. So yeah, I think we've got good understanding around it. And I think these most recent changes really were more protective of the players involved in that registration process. And, you know, credit to ACT government for actually saying, yeah, you know what, this registration stuff is a little bit behind the scenes. What we need from the strata industry is to get those documents lodged. You get them lodged in time, will sort of deal with the back end instead of being a bit held out to dry. If, you know, if those forms are filled in incorrectly, if they're not signed properly, and perhaps they're in the process of registration for a month and then they're requisitioned back to you, you could have a major invalidity situation. And, you know, the reason we hate invalidity is because people naturally rely on these decisions to be valid and start taking steps and doing things in their own life without thinking that they might have to wait for a period before it's unequivocally determined to be valid in circumstances where they think they've made a valid decision. So I think it's good law.
Okay. And most buildings, could you say, in ACT, have they looked at their bylaws since the stage one came out and done a bit of a bylaw consolidation? I know that usually happens in other states around the reforms as they come out.
It was an express requirement under the first stage of the reforms. So all owners corporations should have done so. They wouldn't necessarily, like the smaller B class or some of those more simple strata schemes may not have had much in the way to register. It may have just been the default rules, and a lot of B class and smaller developments do just keep their B class rules, in which case there's no requirement to lodge anything. I believe that's right, isn't it, Shelley? If it's just the default, you don't need to register. But all other units plans based on that stage one requirement or the requirements in the stage one reform should have reviewed, because as Shelley touched on before, there's changes to the special privilege requirements. Any previously granted special privileges had lapsed or would lapse under that stage one reform. So they would need to be considered and included in a consolidated set of rules. And again, many units plans had your rules as one sort of guiding set to live by, and then house rules side by side. They didn't always work hand in hand. They did. So they should have done it. In short, yes, they all should have done it. If they haven't, it's probably a good time to jump on and do it, and just make sure it does address everything that needs to be addressed for your particular circumstances.
Okay.
Yeah, and if you do that and you find that you might have invalid issues, process issues, you know, you aren't alone in that space. Get some advice. Talk to your strata manager first. Talk to a solicitor if you need to. A lot of this is fixable. It's better fixed sooner in time than later in time, because the longer the consequences of an invalid act might go on, the harder it can be to correct or fix it, the more potential prejudice, etc. I'm sure that's pretty clear to everyone, but it doesn't really go away. It needs to be fixed. And so I'd just say tackle it, speak up, raise the issue, see what can be done about it.
Okay, great. Hopefully people, will do that if they haven't tended to them already. And then another question that I had when you were speaking about the subleasing of common property, your favourite one, Shelley.
Yeah.
I wondered if you could provide some examples to us of what that would entail and what the buildings might be looking at introducing.
Yeah, for sure. And I repeat the disclaimer here because something that I'm not a specialist property lawyer, but I know a little bit and enough to know that there are uses, permitted uses in our leases that will need to be looked at and minds turned to. And, all our buildings are different. Everyone's got different permitted uses in there, some broader than others, some more prescriptive. So just make sure if you're considering a proposal that you go and get some proper advice. But on a practical level, Nikki, I think we're talking about coffee carts. I think we're talking about little pop-up vendors. I think we're talking about probably
vending machines. We've had a few requests for vending machines, both fresh food and like the crisps and things like that.
Yeah, that's right. I mean, parcel lockers are already pretty common, but they could be done in a more enhanced way. I think there's the potential for concierge services, any little third-party providers that could come in, that we could conceive of, could come in, with the OC's consent to add something to the quality and existence of the residents in the building. And I think one of the reasons I like it is that it's so broad ranging and it means that owners are able to sort of think about and make decisions that reflect who they are and what they want in their building. And yeah, that's what I quite like about it. But I'm also hoping there'll be just more coffee around.
Yeah, I thought that was a good one as well. I was thinking of the screens that some buildings are having put up in their foyers or their lifts that run adverts as well as information, and then they get a revenue back off the advert. Would that be an example of something that they could consider? Or
I was going to say yes, and Nina looks like she's going to say no.
In a lot of cases, that property is owned by the owners corporation. I know the buildings where we've got it, it's actually common property owned assets. So I'm not sure whether or not that would come into play in terms of subleasing because it's an asset of the owners corporation. But I'm happy to be corrected there, Shelley.
I agree with you, Nina. I think if there were third-party providers wanting to do that, where they were prepared for their equipment to remain, it could fall within these reforms. I was thinking even of, pop-up art spaces, and there's a whole range, I think, of opportunities to we've got a maximum term of 5 years, can't infringe with another special privilege, can't unreasonably interfere with someone's use and enjoyment. But, otherwise it's a new chapter, I think, for commercial enterprise.
Yeah, that's quite exciting.
Sorry, I was going to say, I think the creative people out there will probably come up with a few things that don't even enter our space. But
that's right.
Yeah, I think we'll see a lot of development in that area in the coming years.
And we'd love to hear about it, either through both of you, Shelley and Nina, or if any of our audience sees anything or hears anything or considering anything for their building, please let us know, because, yeah, it is quite exciting. Actually, I think it's a great idea.
Yeah, it's a different one.
It is.
We'll definitely share it back, Nikki. We'll give you a little update on the most interesting ones we find.
Very, very interesting ones proposed.
Okay, well, we'll wait to hear about that. We'll certainly get the information out to our audience if we hear of anything. Okay, well, that just about brings us up to the end of the session. So thank you so much for joining us, Shelley and Nina. We're really grateful that you came on to spend the hour with us, and lots of really great information.
Thanks for having us.
Thanks very much for having us.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.